Hello, I'm Vincent White. I'm an employment attorney, and I'm answering publicly posted questions on abo.com, getting folks the answers they need from an employment attorney. And here we have our first question of the day. If I lived in Virginia and now live in California, can I sue in federal court for damage that occurred while I lived in Virginia? When I was 16, I worked at a well-known fast food franchise. I worked there for 2 years. During my employment, I and other minor employees were sexually harassed daily by the general manager and other managers below him. People had sex in the walk-in refrigerator. The managers referred to the sour cream as cum, and all the while I was a young kid. Parentheses, yes, I am still within the statute. I had very few options for employment in my small town. The sexual abuse was every day and constant. There was unintentional, in quotations, so intentional, brushing up against my body and against the bodies of other minor females and one homosexual male that worked with us. Now that I live in California, and since this is a national franchise, can I sue them in federal court? Aren't franchise hiring policies and code of conduct mandated by the franchisor? Thanks. Okay, and the person did throw their name in there, but I left it out because I just think it's better for that person if I leave it out. Okay, so lots going on here. There's different statute of limitations, right? So every state has its own statute of limitations, whatever laws it has in a state or local level. And then you have the federal statute of limitations for sexual harassment, which depends, bizarrely, depends a little bit on whether or not the state has a local state agency to address this or not. If it does not, then the statute of limitations for the EEOC, the Equal Employment Opportunity Commission, is 180 days. If there is a state agency, then generally speaking, the statute of limitation in that state for the Equal Employment Opportunity Commission is 300 days. Now you're going to say, hey, I didn't ask you about the EEOC. I asked you about federal court. Correct? You definitely did. But generally speaking, you need to first file with the Equal Employment Opportunity Commission before you can file in federal court. And eventually, the Equal Employment Opportunity Commission gives you something called the right to sue letter, which is like a key to getting your sexual harassment case into federal court. But when you get that right to sue letter, you only have 90 days from the day you received it to get filed in federal court. This may be something you've already complied with. This may be stuff you all already know. And if it is, I apologize. Now, getting back to your original question, which was about venue. Okay. So it is possible that you could bring your case in California. And if you speak to local counsel, they may be willing to do that for you. However, it's probably, and generally when you're dealing with employment, this is generally true. Lots of generalities, right? I can't give you firm, this is definitely going to happen, is why I keep saying generally. So I apologize for that. But there's a good chance a court might say, hey, everybody involved, all the witnesses, all the other victims, all the bad actors, the business itself, the employment that took place, all happened in Virginia. That is a pretty good argument as to why this case should be brought in Virginia. I assume when you say, can I sue in federal court for damages now, that you mean, can I sue in federal court in California, not in Virginia? So the answer, if that is what you mean, many judges may say, hey, this is not the best place for this. This would be much more efficiently handled in Virginia. You're the only one in California. Good chance everybody, including the business and all the people and all the witnesses and all the documents, everything, all back in Virginia. So more efficiently, they might want you to bring this case in Virginia. Often in employment law, wherever the employment takes place, that is where the case then takes place that results from the employment, unless you have an employment agreement that states otherwise. Now, you may have signed an employee agreement that states litigation takes place under the rules and tenets of another state. That may or may not be effective. I know, I'm throwing a lot at you here. I'm sorry. So here's the cheat. Here's the easy answer. Start scheduling free consultations, right? Let the attorneys do the work for you. I assume you want an attorney. You might not. Maybe I'm wrong. If so, by all means, let me know and I can try to fill in the details here. But what I really say is try to schedule a couple free consultations with really experienced employment attorneys. See what they think. See if they think they can keep this case in California, if that's what you're trying to do. I feel like they might say they can't, but I could be wrong. And I'd be thrilled if I was wrong, because that sounds like what you want, right? Now, if you have to go back to Virginia, don't be too sad about it, because you probably won't have to go there very often, right? You're probably talking maybe 2 trips ever for this case, potentially. One for the deposition and one for the actual trial. If it actually goes to trial, which most cases don't, I think like 98% of cases do not proceed to trial in our field. The settlement rate is quite high. And then also cases can be dismissed, right, without actually going to trial. So that's a consideration as well. So I would talk to a couple people in California, and then if you can't find anybody in California, talk to a couple people in Virginia. Now, the EEOC component of this, attorneys can handle that kind of in all 50 states, generally speaking, because you don't actually have to be an attorney to handle that matter. The Fed's been pretty clear about this, and so yeah, your counsel in California should be able to handle your equal employment opportunity case, even if that case is in Virginia. So that's something to keep an eye on as well. But it might not be ideal to have somebody handle the Equal Employment Opportunity Commission case and then have to find someone else to handle the federal litigation. That's really not ideal. And the attorneys might not be thrilled about that either. So that's another thing, kind of another detail you're going to have to keep your eye on here. And I'm throwing all this information at you. Before I go, let me just say, I'm sorry. I'm sorry that you experienced that, especially the touching, but all the other stuff too. And if I can help in any way, if I can answer more questions, if there's something I can do, I'm here. No strings attached, obviously. If I helped in any way, consider giving a like and subscribe down below. It helps me to help more people just like you.